one to the table. While the transition is going on, I wanted to give you a bit of background about Ted Posner. He is a partner in the International Trade Group at Kroll & Mooring, who was actually the sponsor for our tea break. He is the former director, was formerly at the National Security Council and directing issues there related to trade and investment. He has experiences on various levels. He's worked at committees like CFIUS, he's worked at the USTR, and in a variety of other modalities. So we're very fortunate to have Ted with us today as a moderator representing Kroll & Mooring. Ted will be following the conference stream on both Facebook and Twitter, and hopefully during the conversation, rather than just being serious and talking heads, this will encourage you all to get involved in the conversation. So that, and there's already been a rather ripping little stream on Facebook and Twitter related to Professor Reisman's commentary. I saw Lisa Bingham chiming in. I saw Danny chiming in. This is wonderful to have this level of participation at this phase of things. So with that, I will let the panel finalize organizing themselves. We have 6 speakers today and 1 commentator, and this is essentially about the past, present, and future of ADR, and today is the past or stakeholder experience.
Well, thank you, Susan, for the introduction. I'll try to be brief so we can get started and follow the strict injunction to be sensitive to time here. I just wanted to say a brief word of thanks to Susan, to Anna, and the organizers of the conference. I'm thrilled to be here and thrilled to have the opportunity to moderate this panel. I smiled a bit at Professor Reisman's remark about the give and take and the constant pressure, not only in the adversarial setting but also in the negotiation setting. I smiled because being at this conference, I see several former negotiation counterparts from Panama, from Colombia, from Thailand, and I'll be very interested to hear their remarks at today's conference. I think since you have biographies of the speakers on the panel, I will dispense with biographies. You can follow along in the program. The format that we'll be following, each of the speakers today will be speaking for about 15 minutes. As Susan said, we will have comments coming in live that I'll be monitoring over here. I will refrain, I think, from interrupting the speakers unless there's a pressing comment in a natural moment to interject a question. Otherwise, we'll wait for the conclusion of the initial remarks, and then I will try to draw from the comments that have come in live during the opening remarks and pose them to the panelists, and we should have a very interesting discussion. So with that, I suppose we'll just go in order, starting with Mark Clodfelter.
All right, Ted, thank you very much. I know you knew my thanks to the sponsors for today's conference, and particularly for the invitation for me to appear and present some thoughts on this very timely issue. I believe that, unfortunately, the issue of finding ways to bring investment disputes to amicable settlement has been underemphasized in the founding instruments of the field. Is this still? But I think that effort is a valuable goal, and I think, as my comments will show, and somewhat seconding Professor Reisman's comments, I think it's a very difficult goal to achieve. It's worthy of serious consideration, however, because the resolution amicably of these disputes, indeed their prevention, is much more consonant with the goal of increasing investment flows than is the conflict model inherent in investor-state arbitration. And I base these comments on many years representing states and private parties in investment disputes, and particularly 7 years in charge of the United States government's defense of claims under investment treaties. What I would like to do today is to focus on what I see are the fundamental challenges to the application of ADR mechanisms to investor-state disputes. And by disputes, I mean disputes that have reached the stage where some form of dispute resolution is sought by one of the parties, normally the investor. Now, these challenges, which I will be talking about, grow every day as the number of investor-state disputes proliferates. We know, for example, that by the end of 2008, 317 investor-state cases had been commenced, 70% within the last 6 years. And with the ever-increasing, if somewhat decelerated, number of investment agreements continues, the number of investor-state disputes will also likely rise. More treaties, more investment, more awareness of the arbitration option. At the same time, I think we have to recognize, for all its obvious successes, there's a great deal and increasing discomfort with this trend. True, the number of disputes may be a minuscule percentage of the possible disputes in the universe. Even this growing number of disputes causes real problems. Investor-state arbitration is a very expensive process for both sides. Parties can anticipate paying millions of dollars in fees, administrative costs, and arbitrator remuneration. We know, as Professor Reisman pointed out, that these dispute resolution efforts are very disruptive of continuing relationships between economic actors and states. The fact that a case goes to arbitration is a public emphasis with some problem with foreign investment in a country. That's something that clouds other efforts to increase foreign investment. And if a state loses a case, it can make a major dent upon its budget. We in the United States frequently take the amounts in dispute for granted. But as Alvaro Galindo reported to me once, the amount awarded in a single case would be the equivalent of a $30 billion award against the United States government based upon a corresponding population. So awards against states can have an enormous impact upon the public fisc. So there are two basic propositions at work. First, that it would be much better if disputes were settled amicably or avoided altogether than to litigate them. And second, that all possible means, including the techniques of ADR, should be brought to bear to increase the likelihood of amicable settlement. And here there are some things that we know and some things that we don't know. As the UNTAD draft study points out, comprehensive statistics on negotiated settlements of investor-state conflicts are not available. But we do know that many cases, in fact, do settle amicably. The UNTAD report points out that estimates are that over the last 2 decades, such settlements vastly outnumber cases actually taken to arbitration. So there's a whole population of disputes that are settled before they ever get to arbitration. We can also draw inferences from recent data from ICSID, as Professor Frank pointed out in one of her blog entries. Nearly 40% of registered ICSID cases have been resolved without a final award. Now, some of these may be cases where a claimant simply chooses to discontinue the proceedings. But clearly, many represent instances where both parties agreed to end the arbitration proceedings in some mutual fashion. Professor Coe estimated in his well-known paper in this area that perhaps 30% of ICSID cases, in fact, settle through negotiations. And the UNTAD report reports that 48 out of the 317 identified investor-state disputes were discontinued following settlement, so it's about 15%. Now, this is a substantial proportion of ICSID cases, and I think there's little reason to suppose that whatever figure is accurate, that it would be different for cases under the UNCITRAL rules or under other arbitral regimes. And what we don't know is why these cases settled and other cases did not. Now, again, Professor Frank posed the question in one of her entries: what would be the value in trying to assess what variables are likely to affect settlement, so that we can help also bring to begin to differentiate reliably between different types of settlement opportunities? And I would simply say I think it would be extremely valuable to undertake a very close study of cases discontinued, for example, in ICSID, to understand the characteristics of the cases and the motivations of the parties in discontinuing those matters. My intuition tells me what some of the correlations would result from such a study. Purely intuition. One, I think we will find that it's more likely that they involve contractual breaches rather than broader government policies, commercial behavior by the state as opposed to governmental behavior. I think we'll find that the measures at issue affect more likely a single party as opposed to a whole class of parties. And this is a point that Yaz made in one of her blog contributions. I think we'll find that they will more likely involve ongoing long-term relationships of interaction between the state and the foreign investor involved. And lastly, and notably for our purposes here, I think we'll find that ADR played a very limited role in any of these settlements. As the UNCTAD report states, despite the existence of rules and facilities dealing with conciliation and mediation procedures, their application in the investor-state context has to date been minimal. For example, the ICSID website reports that even though these rules have been in existence for some 30 years, there have only been 6 cases commenced under the ICSID conciliation rules, none under the additional facility for conciliation, and none under the ICSID rules for fact-finding. So whether the percentage of investor-state cases that settle is 15% or 30% or even approaches 40%, 2 questions arise that are relevant to us today. First, why wasn't ADR used? And second, why didn't the rest settle? So why wasn't ADR used? After all, ADR is a good thing. It saves money if successful. I think that's agreed. It preserves relationships better. It affords the possibility of maintaining confidentiality. It avoids setting perhaps unhelpful legal precedent. Well, there are many possible reasons. There are bureaucratic obstacles to using ADR on the part of state actors, at least. Some people feel there's a very limited pool of people qualified to act as mediators in such disputes. There may be internal limits on authority to settle. There may be real fiscal constraints on making settlement possible. The discussion earlier was the effect of transparency demands upon possible ADR application. And many people have commented that there may just be a general ignorance about mediation and conciliation on the part of many parties to investor-state disputes. Now, one prominent commentator, the late Thomas Volva, had a more jaundiced view. He certainly did not consider that a lack of the ignorance about mediation or conciliation was at issue. And his view was, and I'll quote him, "A considerable arbitration service industry has emerged in the main arbitration centers. It is in the interest of this industry to maintain arbitral litigation as the preferred form of dealing with disputes between commercial companies and between companies and governments." So his view is it's the lawyers who are involved in the process, essentially, who are preventing resort to ADR in these cases. Andrea Valdariaga asked the question, if counsel are in fact familiar with mediation conciliation, then why is it still not used? And I was interested in Mark Cantor's response on the blog. which was that in his personal experience, and especially a large infrastructure project, private investors and state counterparties do not resort to ADR, quote, because they do not want to use them. It was a conscious choice, not on the part of lawyers, but on the part of the parties themselves, not to seek the assistance of third parties in a negotiated settlement. I don't think that the experience in investor statement is necessarily unusual, since the statistics relating to settlements in the commercial area through ADR also show a great underutilization. So there's no easy answer as to why ADR has not been resorted to. And in fact, this really is a secondary question to the other question that I posed, and that is, why weren't the other cases cited? After all, ADR is not important for its own sake, but rather for its ability to bring about amicable settlements. This is especially pertinent when we compare settlement rates, whatever they are, in the investor state area with settlement rates in commercial arbitration, where even though ADR is also low, settlement rates are much higher. UNTAD comments, for example, that approximately 2/3 of all cases filed with the Court of Arbitration of the ICC are settled by negotiation before an award. That's 2/3, much higher than any estimated number applicable in investor state cases. Well, I think there are two main reasons why these other cases didn't settle, and I suspect it relates to those factors I pointed out. Let me just note, though, I don't see that enforcement issues is a big factor in that question. Now, it may become one, and if in fact tribunals do tend to issue awards giving specific performance as opposed to damages, then I think we might see some very widespread problems with enforcement. But with some glaring exceptions in the investor state field, compliance with awards has been very high, as it is, of course, in commercial arbitration. I think that we see many fewer settlements in the investor state area for two reasons. First, the public nature of the respondent and the public nature of the measure at issue. And second, the inability of the parties to assess the merits of the parties' respective cases as they approach negotiation. Now, the public nature of the parties and the measures at issue in investor state cases makes investor state disputes very different from commercial disputes, at least most investor state disputes. The public nature has many implications, but the fundamental problems go beyond issues related to cautious public employees or confused lines of authority or budget limitations, although these are very real problems. The fundamental problems relate to the fact that most investor state disputes arise out of international treaties and are based upon alleged violations of international legal obligations undertaken between two sovereign states. Now, this is quite different from claims based upon contractual promises between private parties. A claim under a treaty standard involves an allegation that a sovereign state has breached its international obligations. This is surely a more severe charge, and it is very difficult for states to voluntarily, even implicitly, concede such a charge. The reputation of the entire nation and its citizens are necessarily implicated in many investor state claims. And in one sense, for an investor to attempt to negotiate with a state is an attempt to negotiate with an entire citizenry. Investor state disputes commonly involve public values, actions of public authorities in the execution of their public duties to advance policies stated in law. Therefore, disputes that arise under treaties raise much more difficult issues. They implicate very deep-seated values concerning sovereignty, sovereign reputation, and the basic role of the state in the management of economic affairs. So, the first real barrier to settlement of these cases is the underlying nature of investor state disputes. The second barrier, the second fundamental obstacle to amicable settlement, is posed by the enormous divergence in decisions on the part of arbitral tribunals in this field on some of the main issues raised in treaty claims. As Mark Cantor noted in one of his blog entries, quote, real negotiation requires some means for both parties to properly assess the relative strengths and weaknesses of their own and the opponent's case. But the ability of the parties in many investor-state cases to make such assessments is severely hampered by the fact that on these key issues, the tribunal could follow any one of a number of different paths to decision. The probabilities of success, therefore, cannot be captured within any useful range of estimation on many issues. And therefore, neither party can get a true picture of what they may be giving up or what they may be gaining through a negotiated conclusion to the dispute. Now, this uncertainty results from major divergences in the views of arbitral tribunals on a whole range of issues. And to be sure, there is uncertainty in municipal law as well, and I certainly take Professor Reisman's on this point. But I believe that the divergencies in this area are markedly different than what you find in most municipal law systems. If investor-state arbitration had been a subject to Professor Hart's book, for example, under the index for certainty in investor-state arbitration would be a notation, look under E for enormous uncertainty. For example, the parties have to ask, is the dispute arbitrable even though it falls outside of the scope of the treaty's arbitration clause, or even though the claimant has neglected one of the prerequisites of bringing a case because it meets the tests of other treaties due to the most favored nation treatment clause in the treaty at issue. The range of outcomes on these questions has been quite broad and has provoked heated differences between tribunals. Does the claimant's activity qualify at all as an investment entitled to treaty protection? Some tribunals have held that the activity must have certain inherent characteristics, such as making a contribution to economic development, for example. Other tribunals have vehemently rejected that view. Certainly, issues of liability and standards of responsibility under treaties are in some cases very much up in the air. May an indirect taking be shown, or will one be held, even though the government measures at issue have left the investor with substantial value? A fair and equitable treatment. Will a claim be limited to proven elements of customary international law, or will standards developed under a semantic reading of fair and equitable treatment be applied? And if the latter, will a claim that the government measure at issue disappointed the legitimate expectations of the investor be limited to expectations based upon specific assurances, or will they include general expectations of stability in regulatory regimes? Similar divides can be found on the question of full protection and security, national treatment, the application of treaty umbrella clauses, the meaning of essential security exceptions to treaty obligations, and so on. These questions are among the most fundamental at stake, and the inability of parties to predict within an acceptable range of certainty what the outcome is likely to be deprives them of basic information necessary to assign a value to any particular claim. And this, I believe, is a serious impediment to meaningful settlement prospects in most cases. Let me just conclude by saying that clearly the structure has not led to a hoped-for level of settlements. This is not because treaties don't encourage settlements, they do, but the propensity of many tribunals to disregard waiting periods, I think, has reduced the effectiveness of such encouragements. For us, the question is whether ADR can make a contribution to overcoming these obstacles. Can third-party involvement lead to a way to make public policy questions more amenable to resolution outside of arbitration? Can ADR lead to a greater understanding on the part of the parties concerning the relative merits of their cases, even in the uncertain world of treaty standards? These, I think, the issues that really confront us on the prospects of using ADR in investor-state dispute resolution. Thank you.
Thank you, Mark. Before I turn to our next speaker, I said I would try to keep the interruptions and the flow of the opening remarks to a minimum. But a number of questions came in while you were speaking, Mark, that I thought might be timely to raise now. Early on in your statement, you noted it would be interesting to study cases that have settled before going to arbitration and why they settled, and learning more about them. And a number of people who have sent in remarks asked, how could we get that data? Where could we get it from? And wondered what thoughts you might have.
I think it would be incredibly helpful if we could study the cases that settled before arbitration, but the data is going to be very difficult. I was suggesting that even among the identifiable cases, those that where arbitration was commenced but then discontinued, whatever percentage it is, I think it would be extremely helpful to understand what are the characteristics of this case, what kinds of claims they involve, what kinds of parties they involve, what kinds of relationships that they involve. That's what I was writing.
Just to add further to the point, the settlement during arbitration, I think, is an important factor for the work. Like I said, it is the prospect of arbitration. It is the context in which one settles, as opposed to you have to be able to find out beforehand what happens. But once they're in arbitration, things are different.
Wonderful. Can I encourage the speakers to move the microphone and make sure that everyone, for the record, is making clear and articulable statements so we can all benefit from your wisdom?
Thank you for that reminder, Susan. And I will try to keep close tabs on time. I'm trying to follow comments coming in, but if you get a yellow Post-it note from me indicating...
Well, I thought I said more time.
But I'll try to watch the clock fairly closely. Our next panel member is Vilawan Mangklatanakul from Thailand. Looking forward to your remarks. Okay, we'll go. I was going down the table, but we should follow the program. That's good. Okay.
The good news is I don't expect to use all my 15 minutes, and the teacher who wants to sort of superimpose on what's been said already was wonderful. I find very insightful comments, sort of a rudimentary framework, and also to sort of answer the question in a very real way, why we are here. My experience with these questions started, I think, with my early involvement in now Chapter 11 cases, and it was the process that I've come to know at the Iran U.S. Claims Tribunal. On the other hand, it was pretty clear that not all of the participants and stakeholders were happy with it. In fact, Makineer and I both recall a rather scathing critique rendered against the Chapter 11 process by the CEO of Metalclad, who we considered one of the winners, was unsatisfied with the process and presented those remarks for about 20 minutes at an ABA conference. All the usual things: unpredictable, too expensive, too slow, etc. About 7 years ago, actually motivated by that speech, I began to think out loud about how a system that involved in a routine way in an already arbitration-centric regime, forms of ADR, might improve the system. And I encountered about that time like-minded people at ICSID, UNCTAD, and in academia and the practicing world. We became known as this informal group of, I think we call ourselves ANA's posse. And under different banners, we set about to collect data, a sort of fact-finding, in places like Kiev, Davis, California, New York, Madrid, and now Lexington, PSC, Seawall, and Malibu. And among the claims we made, which I think among the mediation community are not controversial, question how do they fare in the investor-state world, is that mediation tends to be faster and cheaper, and the outcome remains within the control of the participants. It's a very important thing. This is why we prefer those results. They're more durable in lots of ways. More likely to preserve the investor-state relationship, more likely to facilitate an integrative, non-zero-sum result, reduces the risks posed by the what is a fair level of unpredictability in terms of outcome because of the way the law is processing, this dialectic that Michael talked about. It's private and confidential, which has a good side and a bad side. And if the parties can be convened, it's a big if, there's a high percentage of success in the B2B world anyway, and the figure of 80% is kicked around often. Now, initially, in the many sidebars we had with lots of the participants at these conferences and elsewhere, I would have soon realized there were pretty much three groups of people. There were the unrepentant eye rollers, there were the guarded sympathizers, and then there were the true believers. And I've always thought myself to be a guarded sympathizer, if anyone wants to know my particular leaning. And the straw poll, quite unscientific by Susan Frank's terms, had the score at eye rollers 7, others 3. And that's not surprising, because the sophisticated people we were talking to were involved in the arbitration community, and they knew several things about mediation. First, as I said, it requires someone to succeed in convening the parties. And the parties are complicated enterprises and even more complicated governments that have multiple ministries, difficult decision trains. Who, by the way, has the power to represent the government and speak for it in a binding way? Not an easy question in some circumstances, particularly without capacity having been built to handle these kinds of things. It's a voluntary process. It's not guaranteed to end in a settlement, as arbitration is, for better or worse, and it can be exploited by a party acting without faith simply because it is a voluntary process. If unsuccessful, it will seem to the client like it was a colossal waste of time and money, and that's true whether it's a government client or a private client. And let's be honest, mediation is exceedingly hard work for all concerned. It's a different kind of hard work that goes on in arbitration, and if one has decided that their strength lies in arbitration or their regime is set up for arbitration, there's a singularity of purpose that develops, and mediation can be a distraction. And not to sort of be too cynical about it, but I do agree with Thomas Valdi that it's not instinctively something that mediation is. It's not instinctively something that law firms gravitate toward. It's an essential part of their business model when compared to big-ticket litigation and arbitration. Also, mediation among the participants may be seen as fixing too much accountability, in the sense that compared to arbitration, where the result is imposed by a third party, and therefore that third party can be blamed for not understanding our case, when you settle and have to take it back to your government, taxpayers, or shareholders, as the case may be, the buck stops with you and you have to explain. And it's often better in your mind, in terms of career path and other kinds of very human things, to say, let's trust the arbitrators with this. Mediation has been mentioned, and I think it's absolutely right, may present special problems for states in that there are anti-corruption laws that prevent payments to be made to investors and other kinds of things. And one hears of places where it's actually unlawful to settle a case, and in some places you hear that it's tantamount to an act of parliament to actually get a legal kind of settlement made. Of course, there are multiple ministries, as we said before, and it's not often clear what the team ought to consist of that actually is knowledgeable and can understand it. There is the problem also mentioned, which I completely agree with, that if the timing is improper, we ask states to show up and actively engage with a mind toward settlement when it's too early, before they actually understand. But forget the amount of controversy, just the core facts. And under the idea, it's quite likely that the dispute arose somewhere out in a municipality, and the central government may be hearing about it more or less for the first time when they get the notice. And so I think there's an insight there about the relationship, the existing relationship, and the closeness of the central government to the dispute and to the relationship may tell us what kinds of things get settled. the nature of that relationship. A couple more things. Mediation at the investor-state level to succeed assumes a high-quality body of investor-state mediators, and I think that they're out there, but that pool has not yet been identified. It's not necessarily the brilliant arbitrators who serve that would make good mediators, but the mediator that serves ought to be a reputational peer. I should say mediator or mediators, because one model is a co-mediation model. Reputational peer that would provide for the parties what my friend Bart Legman calls cover, as to say, would be authoritative enough that one could take that back to the relevant constituents and said, as occurred in one of the successful cases, the Sorrel cases. Lord Wilberforce suggested these terms, and these are essentially the ones that he put forward, and who better than Lord Wilberforce, and he's sort of proxy for quality in this circumstance. And so, in that setting, it was probably more important than not what Lord Wilberforce actually recommended, but the fact that he said it that made it more possible for the parties to settle. So somehow, authoritative mediators that give cover to the parties, and those would be people who actually understand, in my book, the investment process, investment law, and could, to an extent, offer predictive valuation. If for no other reason to be able to, as occurs in mediation, call into question the legal premises of the parties involved. And I should say that after about 7 years of doing this with, among various of us, the arbitration seems to be, first among equals, yet expensive, complex, and not satisfying for all the stakeholders. And I think that the eye rollers are down to about 5 out of 10 now. And many of the questions raised, quite rightly, by Michael and by Mark, I think to some extent can be handled by process design. Again, my model is one where mediation is a collateral process and perhaps a parallel process that would engage at various junctures during the arbitration, starting in the cooling off period. And if we can get going with the process at that point and actually make the arbitration unnecessary, then that's fine. But understanding that perspectives of the participants and their understanding of their own case, both factually and the risks of loss, change throughout the 4, 5, 6 years of the arbitration. And that presents mediation windows. The right person stepping in according to certain soft, sort of prefigured windows that people would expect to occur might actually increase the rate of settlement and certainly make for more durable kinds of settlements. I think the way forward includes, and I'll close with a very short list, we need to do things to create a convening bias. That is, it would be useful if over the course of the next few years, quite incrementally, we did things to establish a usage where there's an expectation that mediation might and certainly will be involved in an arbitration process if it goes on fairly long. And that would include capacity building, whereby states are not only informed about the various options, but begin to talk to outside counsel about using as part of their toolbox ADR processes in an inventive way as part of process design. And correspondingly, states ought to become internally organized to capitalize on mediation, to look at it as part of an overall strategy. When one state has a portfolio of disputes, some states numbering 40 or 50 of them, useful to be able to identify, if we can get these data, cases that were particularly well suited for that, and handle those with a more collaborative approach while realizing that some of them will proceed to an arbitral outcome. We need to recruit and train mediators who are reputational pars, as I mentioned before, and we need a serviceable set of mediation rules designed with investor-state disputes involved. And I think we need to continue to study the transparency problem, because one thing that one notices in recent years is the trend toward transparency in investor-state arbitration. And mediation would cut the other direction, because there's only so much public access one can give to the mediation process and still call it a mediation. And this is a problem that's not going to go away, and I think we have to the extent possible, accommodate those concerns. I do also think, though, that with respect to third parties and this collaborative rulemaking process, mediation, at least as a collateral process to ongoing arbitration, may present opportunities for third-party stakeholders to get involved, have input in, admittedly, in an indirect way, but nonetheless have some input. And I'm leaving 2 minutes to myself to be a nuisance later in the program, so I will stop now.
Thank you, Jack. Our next speaker is Alvaro Galindo.
Thank you. I will start first thanking our hosts, Susan. Thank you very much for the invitation, and of course, Anna. Thank you very much. It is an honor for me to be in this room with this distinguished group of scholars and colleagues, students. I was asked to talk about the cons and pros of ADR and arbitration in relation to the experience that I live as the Director of International Arbitration and Litigation of Ecuador. And as you may be aware, it's a great experience since we are in a particular place to talk about an experience. So I will try to convey to you that experience in these 14 minutes that I have here for this presentation. Everything that I would say is just the consequence of my thoughts and my experience. It's not something to be attributable to my government or to the Republic. As my prior life as an academic, as a law professor, in negotiation and mediation, it is an interesting place to be today in all these arbitrations on behalf of the government. And ADR, of course, makes sense during the arbitration proceeding. As Professor Kerry McCormick from Georgetown University Law Center called it, the appropriate dispute resolution is not the alternative to arbitration. And the Republic of Ecuador has used these mechanisms in different stages of its relations with foreign investors. I'm going to talk about a few cases that are on the public realm, so you may be aware of those cases. And some of those are not that public, low-profile cases, on which I would mention those as well. One case that I think is one that is worth to mention is the city-oriented case against the Republic of Ecuador. The city-oriented case was not a bilateral investment treaty case, but a contractual clause case. And the investor used the IPSI mechanism, and during the arbitration proceeding, the parties reached an agreement. and the arbitration was basically put to an end after that settlement. That was a very difficult case for Ecuador. They had a phase of provisional measures. The Ecuadorian authorities, on a certain point of that case, started a criminal investigation against the different representatives of that company. Those provisional measures recommended Ecuador to finish the investigation, this criminal investigation. And I call it recommended because that's the word that is used under Article 47 of the Convention. At that moment, this case under the domestic Ecuadorian judicial system went to the Supreme Court of Justice, and the Supreme Court of Justice annulled the whole investigation, the whole criminal investigation, based on the recommendation of provisional measures by the International Tribunal. After this fact took place, negotiations were more intense at that moment between the government and the representatives of this company. And it finally ended with an agreement on which the company transferred the operation to the government, and it was compensated for the value of that operation. One particular fact that is important for Ecuador in that settlement is that within the settlement, the company recognized expressly the authority of Ecuador to regulate its hydrocarbons law regime. And this regime is under attack in many international arbitrations, and this being an important fact as the precedent for the cases. Another important case that I would like to mention to you today, in the energy sector as well, is the Noble Energy Machara Power case against the Republic of Ecuador. That case was electricity generation, and that arbitration had a decision on jurisdiction by an international tribunal under ICSID. After the decision on jurisdiction, as you can imagine, that was against the state, settlement negotiations started, and they finally reached an agreement last year on compensation was paid to the company. The arbitration was over at that moment, and the company is still, and this is an important difference to the prior case with Sitio Oriente. The company stayed in Ecuador, is still working and producing energy, generating energy for Ecuador, electricity in particular. And there are still some other issues still pending to be solved, this company in particular. And there are still some discussions on other issues that were not solved during the arbitration proceeding, and were not solved in the final agreement that was reached in that particular case. In relation to a construction project, there is a Keyport project, which is a company, a consortium that has an agreement to construct the new airport for Quito, the capital of Ecuador. In that particular project, there were some, as it is called under the agreement, political events that took place under that contract. And the investor brought an international arbitration against Ecuador. Negotiations are rolling at this time. The arbitration was suspended. If you go and you take a look at the ICSID website, you can see that this arbitration in particular is suspended because of agreement between the parties, while the arbitrations are going on. The mayor of the city a few weeks ago announced to the public that negotiations were succeeding. Economical terms were reached, and that was announced by the mayor of the city. But some particular terms are still being constructed between the parties in order to finish an agreement and see what's going to happen with the proceeding that is suspended. That's another issue that is under discussion today. And we have some other difficult cases of provisional measures that have been recommended, as I mentioned before, to Ecuador by international tribunals. The first cases that I mentioned to you are the, I would say, good experiences in relation to alternative dispute resolution on these different arbitration proceedings. On those cases, there has not been a form of a third-party intervention through a mediator or some kind of facilitator. It's just a face-to-face negotiation between the parties, representatives of the companies through counsel, and representatives of the state from the different agencies, the Ministry of Foreign Affairs, Ministry of Industry, the representatives of the oil Ecuadorian company, the Ministry of Oil and Mines, today of non-renewable natural resources, and representatives of the Attorney General's Office, which is the agency I work. We try, as an agency in charge of the, I would call it the judicial representation of the state, we try to advise different officers of the state what the consequences could be of going forward with an arbitration. So this is more or less as simple as what an attorney does with a private client. You advise your client, you tell the presidency what the consequences under an international bilateral investment treaty would be to go ahead with an arbitration, what possible outcomes could come from that particular tribunal, and what obligations would come or raised from that arbitration to the state. With that information, the authorities can make an assessment, what we call an objective assessment as possible of those elements, and take decisions. Of course, as some of the prior commentators, Mark Feldman mentioned it, sometimes there is not enough information, there is not enough facts or case law or the same line of interpretation of different international instruments in order to give an objective assessment of what could be a possible outcome of a particular case. And that, of course, brings uncertainty from the point of view of a counsel who is giving advice to a client. And that's one of the cons of this particular system. Of course, we have heard, I have 2 more minutes, thank you, Susan. Some possible remedies to bring more certainty to the system. This one option that can be helpful, I think, to bring more certainty to the system is not only to bring more capacity building to the states, but to bring more capacity building to outside counsel from the companies. If you have, in particular, a view from economic analysis of the law, and you don't have an incentive to bring to your client objective criteria to try to reach an agreement with the government, because you don't have particular incentives to give that incentive to your client, maybe your client is not going to be particularly inclined to reach an agreement with the government. So I think this is two different ways to approach the problem. Not just because governments don't want to reach agreements and don't have capacity building. I think it makes a lot of sense to see on the other side how much incentives there are to try to reach agreements with governments. Thank you very much.
Thank you, Alvaro. Our next speaker, now properly in the order, is Vilawan Mangklatanakul from China. Thank you.
Thank you, Ted, and thank you for UNTAD and Washington DC to give the opportunity for me to be here among these very able experts. And my presentation today is only to reflect the view from the government side and from the government who only recently experienced the first case of BIT arbitration. So I would just to share with you the points that have been arising in this case experience that I have. So I will have some slides to help you go through this my presentation. So far, Thailand has just one big arbitration case. It's called the waterbound case. But as some of you are aware that we are signatory to UNTAD, but we has never, total exit, I'm sorry, but has never ratified it. Maybe only Thailand among the countries around Asia are not a member of the exit convention. So we have learned a lot from this case. As a whole, in fact, on the whole, the nation in Southeast Asia region has very limited experience with investor-state arbitration when comparing to other regions for Latin America or other places in Africa. Therefore, our investor-state arbitration is a learning experience for us. I'd like to share with you our experience in investment arbitration by addressing two aspects. First, the procedural one, and secondly, the substantive one. For procedural matter concerning the process of dispute management, that's what the problem that we face when we have this, have to go through all this procedure of arbitration, and why during that period we found some discrepancy and some problem with the substantive matters embodied in the BIT agreement itself. So let me start with procedural matter. I will divide dispute management into 3 stages. I'd like to highlight some of the problems that arise in defending the case. Okay. For procedural, there are three stages that we. What are the pitfalls in each stage? For pre-dispute, although there are several cases of investor bringing claim against Thailand, but most of them are based on concession contract. And of course, we have some Thai arbitration cases as well. But those are very commercial contracts. The first bid arbitration only arose in 2007, 46 years after Thailand has concluded its first bid with Germany in 1961. So although dialogue between investor and alleged agency occurred during the case, we do not have a formal mechanism to filter the case. And I believe if we have one, we could prevent a dispute escalating into formal investment arbitration. At the moment, there is some investor from Thailand abroad, and there are certain cases that we are thought of bringing claim against their home, the host country under our BIT. But we have settled among ourselves because those governments decide to pay compensation for the loss that our company has had. So there are certain cases that we can negotiate with the government, and the government ready to pay for the compensation. So that is a case of Thai investor abroad. So during the dispute, what happened is that there is a lack of understanding about BIT itself and on the part of the relevant agencies. The relevant agencies just ask, what is it? What is it? And why are you concluding something like this? This is very normal coming up from the relevant agencies. And it takes time for them to appreciate the state that you are really going to face a defense, the case. And it takes time for them to realize that. So many agencies are not aware what are those international commitments that the government has made over the years. We try in the Ministry of Foreign Affairs to set up the agreement on the websites and everything and try to publicize those. But slowly getting increased recognition. So secondly, there is no permanent coordinating agency when a dispute arises. So it has to rely upon the alleged agency to appoint a working group, an ad hoc working group, and these normally go up to the cabinet for approval of setting up. So, and the lead of the working group is the relevant agency, the alleged agency, which many times have very little understanding about the process and very reluctant to be open about the case itself. Furthermore, there is a lack of central information sharing system, which causes inevitable delay when information needs to flow from one agency to another. So this can take some time, which may hinder the preparation process of the defense. And furthermore, searching for an experienced lawyer in the field is very difficult task as well. And well-known names of lawyers are recommended to the government, but most of them are not expert in the area. And the relevant agency have to think about that. And lastly, language can be a barrier. And the need for translation of every document the government have is very time-consuming and very costly. And every minute that we have with the lawyers and with the counselor and arbitration have to be translated as well. And there is many cases that there is something lost in translation. So that's what we have. So after the case, yes, the case that we have, really has lost the case. And the government are asked to pay a big sum of money to that. And that's, of course, the relevant agency do their best, try not to enforce the award. And I think that is very common in many countries. In the situation where political stability is the main concern of the government, the willingness for the government to accept that an arbitral award in which it is a losing party is not easily expected. And it also has to be accountable and answerable to the public and the media as well. So the case, one of the domestic case that we lost a few years ago under a domestic concession contract, it was huge in the news, or for months, that the government lost this sum of money for the arbitration award. But 6 years after that, this case went through the appeal until the Supreme Court, and the Supreme Court didn't enforce the case on the ground that there is corruption involved, so between the investor and the agency. So the case was dismissed on the ground of corruption that's against public policy. That's in accordance with the New York Convention on the recognition and enforcement of law. And that's what very quiet in the news. So nobody, it's just small print in the news, and nobody knows. Now, when we are talking of the case, we ask the people in Thailand, we just remember when the time the government lost the case, but not the Supreme Court refused enforcement. So that could cause the government concern of their stability. And I mean, you can understand from the current situation in Thailand that this kind of thing, if it happens, it can cost the government its office as well. So the outcome of the award can also have impact on the investment climate and its country image, because of the media can make this if you read from far away, you would think that there is a lot of problem going on, so investors have to think twice going to Thailand or going to the country because of this. So the government will be very reluctant to enforce the award. And furthermore, it is also possible for personal responsibility of the official involved. So the official, government official can be liable for any loss of the damage property as well. So now, let's return to the substantive method. I will touch a little bit on this. That during our case, we found that like most other bids, Thai bids contain many provisions which broad and imprecise terms. For example, fair and equitable treatment. What does that mean? Investment dispute. This is very wide. We have spent so much time in fighting in the jurisdiction phase on what is fall under the scope of the treaty or not, and with the German have to treaty whether it's fall under the previous treaty which doesn't have investor state dispute settlement, or whether it's fell under this new treaty. And furthermore, Thailand has very unusual provision because specifically approved in writing by the competent authority. This space has been introduced in the Thai bid in order to screening, to recognize the screening process of the investment in Thailand. But again, this phase is two-way to convince the tribunal that the protection in Thailand is not automatic in every case. In some cases, you need to ask for the approval for protection. But we have not been able to persuade the tribunal in that case. vague term. The vague term leads to the phenomenon of over-expansive interpretation because the tribunal has determined the boundary of the provision. This coincides with the fact that home state has been out of the picture since the signing of the treaty. And so that this is rather extraordinary that you consider that it is the state that made the treaty itself, but has reluctantly become a victim of its own creation. Without trespassing on the topic of other discussion later on, I would like to make at this point 2 suggestions regarding procedural aspect. I think states need to start thinking of setting up a system to handle investment cases seriously. Maybe not the dispute itself, but the whole investment regime and implementation of BITs in general. And the first thing we can do is that to establish a dispute prevention policy and establishment of the coordinator agency. Secondly, we should think about enhancing the state-to-state cooperation by re-engaging the home state and be more proactive in resolving a dispute. This may be achieved in the form of joint committee, which will serve two distinct functions. First, to act as a forum for disputing party to negotiate for settlement. And its role is not intended to intervene with the substance of the dispute, but to provide a formal forum for them to come and then sit down and talk together and make it public. And it's not under the closed door, and then there's somebody trying to running around between the investor and the state. And secondly, for interpretation of the provision of the treaty, it can issue a binding note of interpretation in arbitration process. I think we have introduced this into the ASEAN, Australia, New Zealand FTA, that when there is certain matter concerning the interpretation of a treaty, then the joint committee should render a joint interpretation, and the arbitrators are encouraged to look at the interpretation. So I do not pretend that these suggestions create any novelty, but I think they seem to be underestimated, especially the role of state-to-state cooperation. We have recently focused a great deal on improving the arbitration system while almost neglecting the crucial role state can play in this task. After all, what we want from concluding a bid is for the state to create a favorable and transparency environment for investors, but not to encourage legal battle between investor and state, and only for dollar and cents. So, thank you.
Thank you, Vilawan. Our last speaker on this panel before we proceed to the comments portion of the program is Ignacio Torterola.
Good morning. Thank you for having me here today. And let me start by expressing my gratitude to Susan. Susan, thank you very much for all the hard work. And to Anna, and Jan, and Anka in general, for raising awareness regarding this kind of disputes, and also for the capacity building, not only with developing countries, but also with developed countries. And thank you for the draft from negotiation that was very useful to consult yesterday night before coming here today. Because of that, as a confidence, I have prepared myself to talk to you about pitfalls and successes of US state arbitration. And it seems that you were more interested about talking negotiations. And for that reason, though I said I was not going to change my speech, I decided to change it. And not only because I would like to listen to about that, but also because I think that there might be interesting things to say about the issue and the Argentine experience regarding that. I'd like to start with a conclusion. I feel that the first point about the US arbitration field, I think that has much improved, at least since the year 2009. Especially last year, 2009, I see like the system coming to a balance and the different players learning how to play the game. I think that that's very useful, and that's part of the contribution of UNTAD and the people that has raised awareness and the legal knowledge about this kind of processes. I will divide my presentation in three parts. First part I will talk about the background of Argentina, the Argentine team faced every time that we are dealing with the case. The second part I will refer to my current appreciation of the investor arbitration rule, and in the third part I'm going to talk about what happened, what has been negotiated, what has not in the case of Argentina. And for that reason, I made these because I think that sometimes people that are in arbitration shouldn't take for granted that all the people are informed about the issues. And I thought it would be useful for you to see what is the cause of the Argentine cases. And the famous 42 cases, which at the end are almost 49 cases. And it's a huge crisis that struck the country in the year 2001. And I decided to compare the 2001 crisis in Argentina with the 2008 crisis in the United States. And this is the numbers that you get when you go and discuss what happened in Argentina. And I think that the graphics are self-explanatory, that I don't need to say more. Poverty in the levels of 40% of the population. That means that almost 20 million of people in Argentina were under the poverty line, 35% of the population in the conditions of very poor people. And this is not something that happened 9 years ago. Yesterday, or the day after yesterday, I'm sure yesterday I'm very willing to distribute about you. Among you was an article from Clarín, which is the main newspaper in Argentina, and said, what is the new profile of poor people in Argentina? And the new profile is that new poor people in Argentina are well educated, and they are people that are entrepreneurs that can organize themselves. I mean, it's the kind of poor that are different, I would say, because one of the features of the 2001 crisis was that it did not strike only the poor population, but also strike the middle class population in Argentina. Indeed, in a country of 40 million people to have more than 20 million people under the poverty line, it means that it struck more than the poor people in Argentina. And well, here you have the same graphics in a different expression, and I'm offering these PowerPoint presentations to you if you like to have them afterwards. Then the second background that the Argentine team faces every time that we deal with the case is the fact of all the corruption that happened during the 90s in Argentina, and end up with the crisis in 2001, not necessarily related, but I'm saying some of the privatization process And for example, I think that here you have to read just the 3 first line. You can read everything, and I also offer the entire paper if you need it. But in Argentina was, and still exists, this idea that most of the contracts that were the result of the 90s were the result of corruption processes. I have to say, not all of them, and this is a special characteristic, as I was sharing with the colleague from the State Department yesterday night, of the European cases, because I think that in that regard, the American cases, because of the PCPA, has been cases in which it was not common, I would say not common, to find traces of corruption. And therefore, in the Argentine population, there is this feeling that all that happened during the 90s has some, say, shadow of corruption hanging over it. And the third point that I would like to raise, and this is something that has originally been written in Spanish, and for that reason I made a free translation for you, that says about what is some of the civil society perception of what ICSID and the World Bank is. And my next point, I'm going to say that this is totally wrong, but it's the background in which we work, and these were PowerPoint presentations that were presented last December in a conference that the Corporation organized in Argentina, and we invited some NGOs who was part of the discussion here, and I thought it was useful to share it with you. Therefore, this is a background in which we take these cases, and for that reason, it's not easy for our office to keep Argentina in ICSID, to keep Argentina in the state arbitration, and it's not easy for us to present to our constituencies when we have an award that is against Argentina, because there is the perception in Argentina that most of those contracts were granted through corruption, and there is this idea of an international conspiracy against Argentina, which I said again, we believe at the Office of the Attorney General that is wrong, but not everybody is involved in the cases as we are. And I think that's, if we have time, we're going to share that afterwards. The second point is in which condition the state arbitration system is nowadays, and I think that it has improved substantially, at least from the year 2003. I'm seeing kind of instability in the decisions, and I'm hopeful that this will continue. I will change this because otherwise I'll distract. And I'm sorry for the ones that were reading that. I'm going to distribute afterwards. Thanks a lot. the PowerPoint presentation. Well, the second issue is that, well, I said that ICSID or the other international arbitration institutions should not be blamed for this. Though I said, and I enjoy here the president of NEC, that we have a lot of expectations about his tenure at ICSID, as I say many times, personally to her, that ICSID and the other institution has to provide for good chairmen in the case that parties do not reach an agreement, and they have to provide for good members of the naming committees. What are the problems with the current system? First, I mean, most of the points I'm going to raise are the ones that Mark raised before. We see that the system is, I mean, the standards are very flimsy, especially the fair and equitable treatment standard that, as Mark said, can encompass everything within it. I mean, the customer international law treatment or the legitimate expectations of investors. And there is not clear where we are going there. Another problem is the evaluation of damages. I think that is a big problem. And probably the last point is that there are a lot of problems with the arbitrators' conflict of interest. I think that this is really a grave thing that is going on in this practice. And now, with all that as a background, I'd like to move to negotiation and what happened with the Argentine cases, with the so-called 42 cases against Argentina. And first of all, I would like to say that the specifications measures were a big negotiation scenario, in the sense that because of the prices, the Argentine peso was devaluated 1 to 4, and therefore the obligations between the parties had to be adjusted. And the whole system was break down because creditors have the credits in dollars, but debtors have the income in Argentinian pesos. Therefore, it was a 4 to 1, 400% impact on the possibilities of debtors to pay to creditors in Argentina. And the same pacification law mandates parties to negotiate, and that's the first point. And because of this tremendous mismatch. And I have to say that this does not apply only to foreign investors, this applies probably to millions or at least hundreds of contracts in Argentina. And most of them has been negotiated. In some cases, the pacification rules have been imposed, and in some few cases, the judiciary in Argentina had to settle the different understanding of where the right price stood. And the pacification law mandates also a negotiation between the foreign investor and, or we say, the concessionaires and the country. And for that reason, a public agency was created, and that agency is called UNIREN. You can go. Probably there is another PowerPoint presentation in it. No, you should have it. Yeah. Answer. And this other information of what happened in Argentina. But I'm going to tell you first. Out of the 42 cases, 15 cases has been settled and discontinued. And all this has been reached through negotiation, and was through negotiation after the exit case was initiated. But there are many cases, much more than that were settled even before arbitration started. And this probably, if we are able to show the numbers in Argentina, what happened after the crisis. But at least 68% of the cases has already been settled. I mean, this UNIREN is a public site that you can consult. And I'm sorry that it's still in Spanish, but I mean, this first PowerPoint presentation shows that all these cases has been settled. Not all have foreign investors, but there are many that they have. For example, Edenor, Edesur, Edelab, Disprocujo, all this has been negotiated and settled, and was settled. And there is another issue that might be of your interest with public hearings. Everything took a public hearing, and for that reason it took so long for many of the cases to settle. Then there are some cases, these are still confirmed cases, not in dispute anymore, and these are the terminated cases. There is, then you have all these other cases that are still under negotiation, but in which even the exit process has been discontinued. Finally, in the graphic it's more or less like this. I have to say that here most of the exit cases are missing. I have an explanation for that, and it's that most of the time what happened is that in one company, the local company had foreign investors that were shareholders in the company, and for that reason the information is missing from there. Anyway, I'd like to conclude, and very happy to answer all the questions that you may have, saying that, first of all, I see the state practice improving, and the states being able to defend themselves. And second, I believe that negotiation is possible and desirable in this field, and it's not something that is going to happen. In the case of Argentina and many other cases, as others illustrated us on that, has already happened. And most of the cases are the cases that go to negotiation. And there are some cases in which agreement is not possible, and those are the cases that you have. Unfortunately, because of the kind of crisis that Argentina suffered, were many cases, but more or less is in the landscape of the Argentine cases. Thank you very much.
Thank you, Ignacio. Before we get to the Q&A and talk about some of the comments that have come in live during the speaker's presentations, we have a commentator portion of the program. Mark Feldman is here. Mark, do you want to join us up here and comment on the remarks from the speakers of this panel?
Well, thanks, Ted, and to Susan and Anna for putting together a terrific program today. I'm here in a personal capacity. I'd like to begin with a few comments on U.S. policy and practice in this area of dispute settlement, and then have a few observations on the very helpful and interesting points we've heard so far this morning. First, as a textual matter, if you look at NAFTA Chapter 11, followed by our 2004 model bit, followed by Chapter 10 of the CAFTA, what you see throughout is consistent support for the idea of consultation and negotiation. In particular, under Chapter 11, I would point to Article 1118, which is entitled, the provision is Settlement of a Claim Through Consultation and Negotiation. And there in 1118, you have clear language. The disputing party should first attempt to settle a claim through consultation or negotiation. Our 2004 model then takes this a step further and has language in Article 23, which states that in the event of an investment dispute, the claimant and the respondent should initially seek to resolve the dispute through consultation and negotiation, which may include the use of non-binding third-party procedures. Then the following year, 2005, you look at CAFTA Chapter 10, and the corresponding CAFTA provision goes even a step further. And this is in Article 10.1.5 of Chapter 10 of the CAFTA, and specifies that the use of non-binding third-party procedures such as conciliation and mediation. So as a policy matter, the text is there. I think what we've been hearing all morning are practical considerations. It's the practical obstacles that we really need to address. And I can say that as part of our practice under NAFTA Chapter 11, pursuant to Article 1118, as a practice, without exception, when we receive a notice of intent from a claimant, the first thing we do, perhaps not the first thing, but one of the first things we do, is contact the claimant and invite them to come in and discuss their claim. Some claimants take us up on that offer. Other claimants do not. But it is an important first step for the claimant to lay out in broad strokes their theory of the case. And also for the respondent, and this is a point I'd like to touch on a bit more in detail, normally when we receive a notice of intent, what we've seen in practice is that tends to be about a 10 to 15-page document. There is very little we can glean from it. It is very broad strokes. And for the claimants who do come in pursuant to Article 1118, it is an important opportunity for the government, for all of the agencies, to meet directly with the claimant and to begin to flesh out what are some of the key theories that may have been referenced in general in the notice but haven't been developed at all. Where does the claimant see this claim going? And on that issue, I would first note that I agree with the points raised by Mark Clodfelter and by Ignacio, that clearly there are some inconsistencies in the jurisprudence which add to uncertainty. The MFN issue alone raises a number of important questions. I would emphasize at the same time, and this point was made by Professor Koh, that as a factual matter, when we receive a notice that's 10 to 15 pages long, we simply don't have the guidance as a factual matter to make informed decisions on settlement. And so this first meeting is an important one. And I would emphasize to claimants out there that if claimants are thinking that settlement is something that they have in mind, especially settlement at an early stage, it would be in their interest to develop more complete initial notices to give respondents a better sense of, for example, what are the witnesses that the claimant has in mind to call? What kind of testimony are those witnesses prepared to provide? How does the claimant see developing the facts of the claim? Notices that we've been receiving in practice simply don't give us this kind of information. At the same time, I would emphasize that we shouldn't put undue pressure on ourselves to reach settlement within 90 days or 6 months. We heard earlier today that settlements can be achieved at various stages of the proceeding. And for that reason, even though a claimant may not have developed their claim initially early on, later on in the case take a number of twists and turns, and we can still have an ongoing dialogue at the same time. But I would emphasize on this point, and this was a point that Mark Clodfelter raised, that Professor Reisman raised, some distinguishing features about investor state. These are public law issues, and this also ties into the transparency point. Normally, in our cases with the United States, we have not dealt with many contract claims. These have been alleged breaches of treaty obligations, often resulting from regulatory action. These are very important public law matters that are at issue, which gives rise to the very important public law interest and participation. And so when you do have the possibility of mediation, we must keep these transparency issues in mind. And I know that Professor Coe referenced the possibility of some kind of public input into the process. It would be challenging, but I think it's something we need to think about. The United States unquestionably supports transparency in these matters generally, and in the specific case of mediation, we get into some new issues that we just haven't had an opportunity to face yet, but something that we need to keep in mind down the road. I would also like to say a word about the importance of educating agencies as part of the process, which we heard this morning. So much of our docket has involved actions taken at the subnational level. And it's one thing to be educating federal agencies on the obligations of these treaties, but particularly when you're dealing with the subnational level, it's simply another level of education and counseling that must go on. And I think for those of us who work directly on dispute settlement, it's really our obligation to lay out, and the point was made earlier this morning, to lay out, as we would in the private sector to any client in the private sector, what are the relevant risks, what are the relevant obligations, so that we can make informed decisions. I would caution that even the agency that has, in a given case, the most direct interest, the agencies whose interests are directly being challenged, that our decision-making takes place through an interagency process. And Professor Reisman touched on this morning, that you can have issues with authority and decision-making. And so even if we are successful in educating the one agency that has the most direct interest in the case, we still then must have a much larger conversation with our entire interagency group. And that group brings a lot of different perspectives to bear. We have some agencies that are particularly concerned about investor interests. We have some agencies that are particularly concerned about regulatory autonomy. And so there is much balancing, and there's a wide conversation that must be had in terms of reaching agreement among these very different views. But as a first step, properly educating the agencies whose direct actions are being challenged, that is a very important first step that can then lead to a larger conversation and a larger interagency discussion, so that as a government we can make informed decisions when it comes to matters of possible settlement in investor-state disputes. And thank you again for your time today.
Thank you, Mark. We now reach the Q&A portion of the program. I think what might be most efficient, there's been a lot of very interesting comments that have come in on Twitter and Facebook while the speakers have been speaking. Obviously, we won't be able to go through all of these, and some of these are framed not really as questions, but more as comments or observations of key points. I've been trying to sort of keep track of them as we've been going along, and I think to get the Q&A rolling, what I'll do is just flag some of the big themes that people following this online in the room have focused on. Four terms really jumped out at me in the comments that were provided while you all were speaking, and those are capacity building, accountability, transparency, and expense. I think a lot of the comments centered around those themes. Let me give you a little bit of the flavor of some of the remarks that came in. In particular, in response to Jack's comments, a number of commenters asked, what can be done to address the issue that you and other speakers raised about accountability with respect to mediation? What can be done to ensure stakeholders that at the end of an ADR process, a mediation process, one can count on the result as one with the same stature, if you will, as an award in arbitration, whether this involves capacity building within the country that is the respondent in the ADR process, or development of a stellar elite core of mediators. How can we do that? Is that a question of changing law school curricula? Is it a question of other kinds of training that we ought to be doing to ensure that level of confidence in the outcome of the mediation process? One theme that was addressed a lot in the comments. Questions related to transparency. Is it, Jack, again, not to pick on Jack, but talked about ADR proceeding in parallel to arbitration, in a sense going back and forth between the two at key windows of opportunity. Does that create issues given the various transparency concerns that speakers have raised? In other words, reverting to a relatively non-transparent process when just prior to that you've been engaged in a deliberately transparent process. What issues does that create? A number of commenters focused on the issues that Vilawan raised in light of Thailand's experience with respect to investor-state arbitration under a bid, and wanted to know whether the issues that she raised, particularly in the post-arbitration phase, are issues that other countries, since we have Argentina and Ecuador represented here, are those issues that you've encountered as well. Another question came up again in response to Vilawan's remarks about language. Are the language issues that she identified issues that others have encountered in their experience? A number of commenters focused on the observation that several speakers made that various forms of ADR go on behind the scenes and without getting a lot of public attention anyway. Given that fact, given that phenomenon, what can be done to impose some kind of formality on that process through facilitation or otherwise? And then a number of commenters focused on the point that Mark Feldman made at the end, and that I think has been touched upon by others, which is questions related to sub-federal measures or sub-central government measures, so that when a dispute involves a sub-central government measure, what relevance does that have for the possibilities of ADR? Coming back to Mark Clodfelter's point at the beginning of this session about factors that may weigh in favor or against the likelihood of ADR. Does the fact that the measures at issue are sub-central government measures make it more or less difficult to engage in ADR. So that's my very rough, crude attempt at trying to synthesize the comments that have come in. All very interesting comments, and I understand will be available for people following the blog to read online later. Would anybody like to take up any of those themes? Jack?
If I understood the accountability question, it was about the stature of the settlement, not to achieve something akin to an award. There's a formalistic answer, which is one can take a mediated settlement going on in the course of an arbitration and have the arbitral tribunal convert it to an award on agreed terms, and it would be, I think, most degree enforceable under the convention, the exit convention, for example. There's that possibility. And in terms of the substantive stature of it, it goes back to the, I think, quality of the mediator and the reputation of the mediator. Many of the persons who now arbitrate have tremendous, distinguished careers, would, I think, add a lot of authenticity, so that if the kind of person who would be equally qualified or even, in a sense, a part of a more rarefied group would be the mediator. And of course, the trick is recruiting those people to do it. That would, I think, give it a tincture of authenticity and legitimacy.
Others like to pick up on some of those themes that have come in over the course of the panel?
Well, I can comment briefly on the issue of subnational municipality involvement. I think it's understood that the violation is considered a violation of the state, which is represented by the national government. In the United States, at least, that means that if a violation is found, irrespective of where the measure is instituted, the federal government will be responsible for paying an award. At least there's been no law enacted to change that assumption. And also, in the United States, NAFTA prohibits the issuing of awards for anything other than damages. So as long as those two things are there, you really just have a political issue if it's a local measure. And local governments have been very vocal in some cases when their measures have been questioned, even though they don't appear to be threatened with an award of damages against them, or threatened with anybody telling them they can't do what they did. So I think it's a manageable problem at this point. Under other bits, there's no limitation expressed, at least, on the powers of the tribunal and their awards. And I think in some other states, the question of where the effective obligation will fall is an open question, or one that expressly provides that the offending level of government will bear the burden. There, I think you got a real issue there of successful negotiations at the federal level without very active participation of the local community.
I raise a question, sort of picking up on that tangentially, perhaps, and going to something that Mark Feldman raised and that stimulated a number of comments online, which is this issue of providing more detailed information in a notice of intent as a way of getting to a more robust conversation before you get to arbitration. Some might react to that by saying, well, you just want to see our arguments earlier on, and you want to see, you want more time to respond to our briefs, essentially. And this goes to the question of political accountability. A number of speakers have said something difficult about reverting to ADR is the problem of accountability to one's stakeholders back home. If a claimant knows that, and a claimant knows that that's an obstacle the United States faces to pick on the United States, since this came up in Mark's comments, would they be wrong to assume that the likelihood of settling the dispute in that pre-notice of arbitration phase is minuscule, and therefore not to do the kind of things that you were suggesting, Mark, even though on the surface they might appear to lend themselves to a negotiated outcome.
Could I make a few comments? Thanks, Ed. First, I'd like to clarify that the NAFTA FTC has issued guidelines for notice of intent, and I don't in any way mean to imply that a notice of intent must include anything beyond those guidelines. But the point is, if you're a claimant that is particularly interested in settlement, a 10 to 15-page notice of intent without a lot of follow-up afterwards is probably not going to do it. So claimants have different motivations for bringing their claims. And if settlement is not up there, you're more than welcome to follow the FTC guidelines and file your 10-page notice of intent, and that's not a problem. But if you are very much geared towards settlement, we need to see a case being made. And it doesn't necessarily have to be limited to the four corners of the notice. Again, we invite parties without exception to consult, and a lot of this can come out in consultations. But I'm just suggesting that if you are looking towards settlement, especially at the early stage, as a government, we're going to need to have a firm understanding of what your case really is.
Why don't we take some questions? Yes, please.
Yes. Well, I would like to construct upon some of these thoughts. And the first thing is that in the case of Argentina, we have faced a lot of cases in which the measures were not at the federal level, but at the level of the provinces, and which are some national entities. And in that regard, I think that an education process is very important in the following the same lines that the UNCA draft refers to the Peruvian. I think that that's an example that my work following. What we are doing so far is we convene a meeting once a year of all the attorney generals. Every council in Argentina is a federal government, very much like the United States, and we convene a meeting in which we bring over all the attorney generals and we discuss these kind of things. And we try that with this meeting, some changes are feel likely to be produced internally.
Some questions, and pardon me if I don't know names, it's difficult to see, particularly some of the placards in the back. Yes?
I have two questions. One is mainly for Ignacio and Álvaro, and also relates to what was discussed by Mark. I mean, the fact that from your experience, which is already significant in the Ecuadorian and the Argentinian cases, is it easier for you as public officers to reach agreement once the arbitration has started? That is that the institutional context of the arbitration and the fact that the agreement will be included in an award that help the settlement of the case? And the second question, the second question is that I would like to insist on an issue that came up twice this morning, one by Professor Cole and the second one by Álvaro, and that is also part of the blog exchange with my handler that Mark Clodfelter referred to, and is the role of counsel in the lack of use of ADR. And then we all know that lawyers in the litigation groups of the law firms, they are always looking for a case, and they invest quite a lot of money and effort in marketing their services for basically having these arbitration and these cases. So when finally the case comes, what is the interest basically of the group and of the lawyer to propose ADR or the use of ADR?
Yes. Thank you, Andrea. I would answer that it depends on the case, to your first question. It depends on the case, because if, as an officer of the state, if you are counsel for the agency or counsel for the republic, and you go through the case and the facts of the case and the argument and the law applied to the case, and you see that it's a good case for the investor, you might be inclined to have negotiations in order to reach an agreement. If you can see that you have a risky case to defend, you will be more inclined to reach an agreement. Of course, if you have an arbitration going forward, the incentive is bigger to reach an agreement. In particular, if the amount that is claimed is a huge amount for the state. But I said it depends on the case, because last night after dinner that we had in this beautiful university, I had a phone call with counsel for an investor on which I said, we can start negotiations, but if you want to start negotiations, you have to have one that is your client, the one who owns money to the state. Under that umbrella, we are ready to start negotiations. So if you have a frivolous claim before you, and the other party thinks that because you have in many cases under arbitration, you're going to be inclined to reach an agreement with all of them, they're very wrong. We're going to be fighting these cases under the law, under the agreements, with all the tools that we have for the years to come. And we're going to try to reach agreement with those that, of course, have the benefit of a good case and that is politically possible to reach an agreement, and that the other party is inclined to reach an agreement.
Thank you, Alvaro. I think I know the question was also posed to Ignacio, but I see Susan moving in here, which is telling me we're probably close to our we're past our.
We are actually past, and the reason I want to keep us all on track is the WNL law students are going to be coming out of class in about 10 minutes. And we don't want to get caught in the hallway and therefore deprived of our lunch. I want to feed you all. But I wanted to first thank all the panelists and the moderator, particularly Ted, for the wonderful job. Lunch is a ticketed event for those of you with tickets or the key participants. I would invite you to follow the student liaisons, the people that have yellow tags. They'll direct you to the faculty lounge, which is around the corner and up some stairs. For those of you who are not attending the ticketed lunch, I would encourage you to go downstairs to the brief stop and get yourself something to eat there. We'll reconvene at 1:15 for panel 2. Thank you so much.